And hello, I'm Chief Investigator Brendan Keefe with Atlanta News First, and I'm joined by Investigative Reporter Andy Pierrotti. Andy, always good to have you here.
Glad to be here.
And we are live right now on ANF Plus, that's Atlanta News First Plus, and we're representing Atlanta News First Investigates because I'm not sure if you heard, maybe you haven't, that there have been some indictments in Fulton County that have captured the attention of the nation. And the big thing that we're here to do is sort of inform you about the vagaries and nuances of Georgia that make this case very different than all of the others you might see around the country. You're going to see a lot of national coverage, and frankly, a lot of the national coverage is just getting it wrong because they don't know Georgia law like Andy Pierrotti does. Andy, anything sticking out that you want to know that I might be able to answer?
I want to know a little bit more about your thoughts on these RICO charges. You worked in New York City. You covered Rudy Giuliani when he was mayor there. He was sort of a big proponent of this. Walk us through these RICO charges and what they mean and maybe some misperceptions of what's been out there so far.
Yeah, people are getting a lot of things wrong, and we can correct the record on that. But you are right. So Rudy Giuliani wasn't just the mayor. Before that, he was the U.S. Attorney for the Southern District of New York. And he used RICO like a bludgeon. I mean, this is what he did. He went after mobsters. The Gambino crime family, the Genovese crime family. There were three big families, the Colombo family in New York City, and he went after the remnants of those gangs, of those criminal mafia enterprises using federal RICO. And now Rudy Giuliani finds himself indicted in a state RICO case in the state of Georgia. Just a stunning fall from grace that's been well documented, and this seems to be the sort of period or exclamation point, although, of course, he's innocent till proven guilty. You had mentioned, Andy, these misconceptions. Well, what's interesting is I'm hearing all over the national press, and I kind of bought into it at first myself, that there's this mandatory minimum sentencing for RICO in Georgia of 5 years, that a minimum 5-year prison sentence. And it's true, sort of, kind of. And, because we know the OCGA, that's the official code of Georgia annotated, for the geeks like me out there, but for everybody else, that's the law in Georgia. It's the official law. And the law for RICO basically says that the sentencing is 5 to 20 years in prison. So you're like, oh, okay, that's a minimum of 5 years in prison. What it doesn't say is what a judge can do, and you know this being in court all the time, is that a judge can sentence someone 5 to 20 years, say, okay, we're giving them 5 years in prison, and then immediately suspend that sentence and instead say you're on probation during that 5-year period where you otherwise would be in prison. The sentence is still there and can be reinstated if they violate that probation, but essentially they're not sent to prison for those 5 years. But the other thing is there's a footnote in the law that says, or they can pay a $25,000 fine. So there is no mandatory minimum sentence in Georgia. It looks like there is, but in reality, there isn't.
And it's this prosecutorial discretion that you're sort of talking about, or in this case, maybe the judge's discretion. And that sort of segues into this new law that Georgia passed earlier this year that created a commission to investigate complaints against district attorneys for alleged misconduct that some believe could potentially be a mechanism to kick Fani Willis out of office.
Well, that's interesting. So I know you've done your research on this, and this law was passed, again, to sort of give the legislature and the executive branch the ability to remove a district attorney for misconduct. But does it define that misconduct enough where it can't be used for political purposes?
And that's what Fani Willis was saying in a Senate Judiciary hearing in February when this wasn't a law yet. It was sort of proposed, and she was addressing the lawmakers that were sponsoring this bill, concerned with that prosecutorial discretion, saying, hey, potentially you're saying that if I decide to reduce the sentence or sort of figure out a way to still utilize my resources and my authority without maybe, putting someone in prison for years or for life, is that going to be potentially a complaint against me that will lead to me being removed from office early? And what she actually brought up was she believed that there is no coincidence that in 2020, the number of minority district attorneys that were voted into office in Georgia was overwhelming. There used to be 5. It's now 14, and if you add up all the constituents of those 14 district attorneys, those 14 minority district attorneys, that's the majority of the Georgia population. And so she was insinuating race as an issue. Now, one of the sponsors of the bill certainly pushed back and said race has nothing to do with it, but that's one of the reasons why she said that they actually created that, is that Republican lawmakers saw Democrat-controlled areas electing district attorneys that maybe were not enforcing the laws that they wish they would have, and here you have this commission that can essentially take the will out of constituents, out of the folks that put them into office, and potentially remove them before the voters get a chance to have another opportunity to put them in office or not.
Oh, do you get a sense that the Trump indictments that were, likely to come down the pike and now were part of that calculus? Or do you think it was more focused on prosecutors like the district attorney in Athens Clark, for example, or the case we saw with Ahmaud Arbery?
I think it depends on who you ask. There is a perception, and perception is what people believe they're seeing in reaction to things. So it's real for them. But I think before even Trump was elected, there were concerns with district attorneys not doing their job. So I don't want to say that there weren't concerns like that before the 2020 election, but I think what they're seeing is they're seeing sort of like, here's the facts as I'm seeing them. They weren't necessarily concerned enough to create this commission when district attorneys weren't doing their jobs before the 2020 election. And now, okay, sure, you're not saying race is part of it. Sure, you're not saying that the Trump indictment or the investigation was part of it. But if you look at the facts and lay them down, that's the pattern that they see for their reality.
I'm about to ask you the million-dollar question, but let me set it up first, which is that, here in Georgia, the president at the time, Donald Trump, and Mark Meadows and Rudy Giuliani and all of this cast of characters that are now named in this indictment, and even unnamed co-conspirators, were pulling all the levers of government. They were using all the powers of the presidency, all the powers of government to try to change the outcome of the election. Now, of course, their argument is that this was trying to overturn an election they believed was fraudulent. And of course, the argument of the indictment is that they were trying to fraudulently, essentially it was one side was saying the election was stolen, and the other side is saying, no, they were actually stealing the election. So we know that these people and their supporters are willing to use whatever is at their disposal to alter the outcome of things that have Georgia-wide and nationwide implications. So that's the million-dollar question for you is, do you think whether or not this law was drawn up targeting Fani Willis and possible Trump and Trump co-conspirator indictments, whether or not that was the intent, could they use it to diffuse this investigation?
Yeah, they certainly could. And as you've seen in other reactions to other indictments, they are going to use every lever that they can to delay or try to change the narrative. And this is potentially an easy way to do it. Find the smallest of things to complain about, submit it to this commission to investigate, and I can easily see someone doing that in the Trump, organization to either delay or discredit this district attorney. So we'll see what happens, but certainly it's something that a lot of people are concerned about and wondering whether it'll happen.
Not a lot of people are talking about this, but it turns out that there's this federal law that says if a president or other high public official commits a crime and is charged with state crimes that have to do with their official position, in other words, an act they commit under the color of their office. So President Trump acting as president, calling Brad Raffensperger, that could then be removed to federal court. I don't want to get lost in the nuances of it, but in fact it would likely be, if this prevails, if this is what they try to do, that it would be removed to federal court, but Fani Willis's office would still prosecute, and it would still be prosecuted under state law. But the net effect is that instead of a jury pool from Fulton County, you would have a jury pool from all of North Georgia, the Northern District of Georgia. And that would be obviously more palatable for the former president. There is a really strong argument for this, only because on that call wasn't Donald Trump and his campaign. It was Donald Trump and his chief of staff in the White House. Their argument could be, and I suspect it will be, that he was acting as president, and he's going to say, hey, because we believe the election was stolen, this was about election integrity, so I, as president, was calling the top elections official, not as campaigner and candidate Donald Trump, but as President Donald Trump in my official capacity, and therefore you have to remove the case. And what's interesting, Andy, is the 11th Circuit U.S. Court of Appeals, which governs our area in terms of the federal appeals court, they have precedent case law, unlike other circuits, that may allow for this broad interpretation, which does lead to the question of what's next. Do you think in this case, in terms of without going into all the details of the indictment, what do you think the defenses are going to be?
I think that they're going to pull out all the steps. I think they're going to try to delay this as long as possible because we're in the middle of an election cycle right now. We're very close to it. Another thing that we haven't really touched on that sort of you sort of hinted to is the amount of resources that it has taken to get to yesterday. The 2.5 years of investigating Trump that Fulton County DA spent, the millions of dollars likely spent in resources, and we're talking about attorneys, paralegals, security. And to put it in perspective, we don't know the total amount so far, but the first few months of the U.S. Justice Department's investigation into Trump's mishandling of classified documents was over $9 million in tax dollars resources just to investigate just the first few months of that investigation. And to put in perspective of why some defense attorneys here in Atlanta, longtime attorneys, are frustrated, is that they're seeing all these resources for these individuals, for this investigation, but they have clients that have been waiting for years for their day in court. Some of them who have been arrested, booked in jail, but never officially charged with a crime. I've got some numbers that I want to throw out to you that I think are just really staggering when you think about it. We're talking about last year alone, 13,000 cases in Fulton County that were unindicted. And many of these people are languishing in jail. Here's some numbers that we got just yesterday from the Fulton County Court Administration. 1,200 people behind bars who are unindicted. Again, these are people that are
in jail
right now that are people that are waiting for the DA to decide whether they're going to present this to a grand jury or not. And then an additional 1,400 individuals who have been indicted but are simply waiting for their day in court, waiting for trial. I've spoken with attorneys that have been waiting 3, 4, 5 years for their cases to move forward.
And so when Fani Willis says, "Hey, I'm ready to take these 19 defendants to trial in 6 months," that would be, in your view, a much more accelerated process than the typical defendant in Georgia would get.
100%. And the only reason why is because Trump has the money and resources, and these individuals, the majority of these individuals, the numbers that I just spoke about, these are poor individuals that can't afford an attorney on their own.
Wow, and I know your excellent investigative series, The Sixth, pointed that out, referring to the Sixth Amendment, because you're entitled to representation, and a lot of these people who are languishing in jail are simply waiting on a public defender.
Yeah, it's we have a crisis in Georgia that is underreported. Is that the number of individuals that need an attorney is in the thousands, and they are stuck in jail across Georgia. Some waiting. We found one guy waiting 10 years for his day in court. So it's an unprecedented crisis happening in Georgia. So defense attorneys, longtime defense attorneys, are sort of dealing with all these cases, and then they see the amount of resources and time and money spent investigating Trump. It's not that they don't believe that, that's not important, but they're just saying, all right, where's your priorities? Is your priorities trying to spend all this money and expediting this case when there are people that are languishing in jail, some of them not even officially charged with the crime for years, waiting for their day in court?
Well, and does that give fuel to the conspiracy theorists who say there's a two-tier justice system, not just rich and poor like you just described, but Republican and Democrat, where the Democratic district attorney has, filed indictments against the leading Republican candidate for president? I think obviously the objective viewpoint is that, crimes were committed, they need to be prosecuted. But the conspiracy theory right now, certainly the supporters of Donald Trump would say, this is all political. The fact that this is moving forward so quickly and that these resources have been dedicated while others have not to, say all of these other defendants you just described, does that add fuel to that fire or at least give evidence for that argument?
Yeah, it certainly doesn't help. And more fire to that community is that fictitious document that was uploaded to the county's website that
what
publishes.
Have you learned about that? I know you heard about, or you looked into this.
Yeah,
what you found about that?
Reuters was the first news organization to report it. saying that it was briefly up on the county's website. The county uses a software system called Odyssey, and it was published on their website, an exact copy of Trump's indictment. It was taken down. The clerk's office responded in saying it was a fictitious document, but didn't provide any other explanation of who did it. Was it an accident? How was it done? We've asked all these questions. We're waiting for an answer. We don't know whether we're going to get an answer to these questions, but it seems like pretty easy answers when you know that this software system likely has an electronic audit trail that can identify some of those indicators, some of those data points. The district attorney addressed this last night, basically saying, it wasn't me, I had nothing to do with it, but someone likely provided a copy of that indictment, unauthorized document or fictitious document to the clerk's office. And according to longtime attorneys that I spoke with, the only office that would have had the ability to upload that document to that Odyssey software system would have been the clerk's office.
Right, and there's all indications that it wasn't the final indictment, obviously, because the grand jury hadn't even begun deliberating, but it was a close facsimile of what at least the charges ended up being.
Yeah.
So in other words, this wasn't a fictitious document that someone just made up. It was a document that was filed that wasn't supposed to be, or at least uploaded that wasn't supposed to be.
Before the grand jury even had an opportunity to vote. And that's what Trump has said in some of his responses, saying, well, how did this happen? Seems rigged to me. It just adds fuel to the fire, unfortunately. Whether or not it was an accident or not, the county, the clerk's office should use this opportunity to get answers to these things, not let them linger for days or weeks at a time.
Well, I've never heard you ask a question that didn't end up with a records request, so I'm assuming you're going to be filing for that audit trail under the Open Records Act to try to find out exactly who did this and when and all that.
Already done. Hopefully we get some answers.
See, of course you did. I knew you did. I didn't even know that in advance. Is there anything else about all of this that you'd like to ask me, having spent, having not slept last night reviewing this indictment?
I'm just really impressed of the amount of indictment charges, and I'm wondering if you can maybe clarify what is the common thread that all of them have linked together, and why do you think this DA chose RICO as that?
Well, it's a great question, Andy, and really the overarching theme is that this was a criminal enterprise, which is by the way, step one of showing that there was a RICO conspiracy is there has to be an enterprise that has a common goal. And the common goal here was to overturn the 2020 election. That's actually not disputed. Everybody agrees that they were trying to overturn the 2020 election. But one side, Trump's side, would argue that they were trying to undo an election that was rigged against them, whereas the indictment claims that it was a criminal attempt to overthrow the will of the Democratic process and the voters, and to overturn the voters. But one thing's in there that really sticks out to me, that compared to all of the other things we've seen, in terms of, remember, there's 3 other criminal indictments that Donald Trump is facing. First is the federal documents case. That's the Mar-a-Lago documents case, unrelated to January 6th and to Georgia. Then you have the January 6th indictment federally, the Jack Smith indictment. Both of those are Jack Smith's office, the special counsel. And that is about, essentially has a lot to do with Georgia. Georgia's named all over that federal document. And there is some overlap between that and the Georgia state case here in Fulton County. And then you have the Manhattan District Attorney, Alvin Bragg, who has filed criminal charges related to the Stormy Daniels hush money payments. And so all of those are criminal charges that are waiting. But here's the big difference on this one. In those federal cases, we're talking, the victim is the American people. That's kind of amorphous, right? These are crimes against the American people. Well, the American people are kind of important, and the democratic system is very important. But in this case, here in Fulton County, when you're talking about these alleged crimes, is that you have actual sort of everyday victims, alleged victims. So you have Ruby Freeman. You and I, when we were working together in 2020 and 2021, we didn't even use the name Ruby Freeman, even though we knew her name. We didn't mention her daughter, Shay Moss, because their names were being dragged through the mud on one side of the political aisle and on media outlets that were leaning that direction. Rudy Giuliani made very salacious allegations against Ruby Freeman and Shay Moss, you know, saying they were passing USB drives like they were crack vials. I mean, these were obviously, you know, dog whistle, or, you know, not even dog whistle. They were, you know, obviously bordering on racist, if not racist, comments against Ruby Freeman and Shay Moss. Remember, these were everyday election workers who volunteered. In fact, they'd worked many elections, and they were accused of essentially being the masterminds of this grand election scheme to overturn the Fulton County election, and they had to go into hiding.
Yep.
And now there are actual criminal charges for what happened to them. You may remember I knocked on the door of a 96-year-old woman who was falsely accused.
That was a memorable moment.
She was accused by the Trump campaign of voter fraud, and all she did was she voted with her registered name, Mrs. James E. Blaylock, and her husband, James E. Blaylock, had died years earlier, and she was accused of voting in his name, and she didn't. And that was on national television. That was on Tucker Carlson, and it came from the Trump campaign, and nobody checked it out. We just knocked on her door, and she answered, and we checked it out with election officials. It turns out she wasn't committing voter fraud. So these are real people, you know, that are salt of the earth people who were targets of this attempt to overturn the election. And now it's part of an alleged criminal conspiracy that's now indicted in Fulton County.
And in 6 months, we will know potentially whether some of these individuals will go to trial.
Well, thanks, Andy, for joining me here. I'm going to continue on and answer some questions from YouTube here. Thanks for all of your deep investigative work. I know that this is not the end for us. This is just the beginning. Our entire Atlanta News First Investigates team will be digging into everything in this indictment, and we'll obviously, you know, this is the other thing. It's all going to be televised. At this point, it doesn't sound like there's any compelling reason to prevent cameras from being in the courtroom, unlike all of the other venues where Donald Trump is facing charges. So expect to see an arraignment possibly next week or in the next week, next 10 days, and then perhaps even a televised trial before or after the 2024 presidential election. Any final words, Andy?
No, I think we wrapped it up.
All right, thanks for joining us, and I'll see you later today as we continue our investigation. Next, what we're going to talk about is sort of how this is affecting Georgia, what's different here, and why, if you live in Georgia, you should care. And the reason you should care is what you have is, as Andy just described, all of these resources that have been applied. But also there's some really interesting nuances to all of this. And one of the nuances is these tweets that were sent by Donald Trump when he still had a Twitter account. His Twitter account's since been restored under new ownership, as they say, x.com. And what you have is tweets that Donald Trump had sent. And just looking at all of this, we've, what do we have up here? What is this? I'm sorry. Just not sure what we're showing. I apologize. Oh, I'm sorry. This is Fani Willis's email. Sorry about that. So I had to put my glasses on because I can't see anything without them when they're on the screen. But so here's what's interesting. Donald Trump's tweets, they're not crimes. It's not a crime to tweet. It's certainly not a crime for a politician or a political candidate or the President of the United States to send out a message over the internet. What they're arguing, though, in this indictment is that those tweets were in furtherance of a criminal conspiracy. So asking, you know, sort of saying Governor Kemp should step in and overturn the election by tweet is in furtherance of the goal of the conspirators, according to the indictment alleged, to overturn the election. And this was an element in the crime, if you will. So what's interesting about RICO is there can be things, there are acts and statements that are in and of themselves not crimes, but can be actions in furtherance of a criminal conspiracy. And that's one of the reasons RICO, while there is a burden to overcome for Fani Willis and her team to get a jury to accept that, hey, this is a criminal conspiracy and a criminal enterprise. Once you're over that, there's huge benefits to charging RICO because you can allege acts that are, again, not in and of themselves crimes, but can be elements toward the furtherance of a criminal conspiracy. And what you really have to show is that there was an enterprise, that they had a corrupt criminal intent, and that's going to be a big one, I think, because if again, the burden of proof is on the prosecution. They have to prove it beyond a reasonable doubt. Donald Trump and the other 18 co-defendants don't have to prove anything. But if they argue, Donald Trump, look, I actually believed the election was stolen. Well, then is there criminal intent? If you really think the election was stolen, there's no criminal intent. In the law in Latin, it's called mens rea, which is, hey, if there's no criminal intent in Donald Trump's mind, then he's not committing crimes. He really thinks he's saving the election. That's where Fani Willis's evidence comes in that 98-page indictment. There's all sorts of evidence. And then, of course, there's more in Jack Smith's indictment for the January 6th case, where, the evidence shows that Donald Trump was informed by his own people, up to and including Bill Barr, who was the Attorney General appointed by Donald Trump, that there was no evidence of corruption, determinative corruption or rigging of the election. And so if he was told that and then continued to believe it, would a reasonable person make that assumption if, their own Confederates, if you will, their own appointees are saying, no, there was no stolen election, there was no, determinative fraud committed in the election, and then you're still saying it. And so was that a lie, I guess, is what is the question. And, the lie actually becomes a matter of, a crime or not, because if he intentionally did these things in order to overturn the election, it could indeed be a crime, but it does come down to that criminal intent. So here's another one of those nuances in Georgia, because I just mentioned Donald Trump's tweets. And those tweets, essentially, really bashing Governor Kemp. He went after him, even after the fact, tried to get him not reelected. That didn't succeed. Same thing with Brad Raffensperger, the Secretary of State. They're both still in office, and Donald Trump isn't. But there was a real attempt to get them to bend to Donald Trump's will to overturn the election. That's undisputed. I mean, it's documented. And that comes from those tweets. But there's a new tweet. They don't call them tweets anymore because Donald Trump has his own platform. Once he was booted from Twitter, he started Truth Social, and that he, has his name on that, and has financial interest in it. And he sent out what they call a truth, which is essentially a tweet or an X or whatever they're calling it now. And this yesterday was basically telling the former Lieutenant Governor Jeff Duncan not to testify. Now, pay attention to this for a second. Because I can get, hey, and I'm paraphrasing here, hey, Jeff Duncan, I don't want you to testify. Sure, of course Donald Trump doesn't want him to testify because he knows that he's, not in favor of what he did, and he thinks, Jeff Duncan's been on the record for a long time as opposing Trump's efforts to overturn the election in Georgia. But when someone is subpoenaed to be a witness before a grand jury, and you, as the target of that grand jury, are saying, don't testify, that is interfering with a witness, not just intimidation, which is a more serious crime, but in Georgia, just interfering with a witness or trying to influence a witness. Influencing a witness is in and of itself a crime. Now, this has not been charged. I'm not alleging that it occurred. What I'm saying is stay tuned to this space because it's very possible that Fani Willis could seek additional charges, a superseding indictment that includes influencing or attempted influencing of a witness, namely Jeff Duncan, the former lieutenant governor of the state of Georgia. Fascinating because, and this has happened already, we've seen multiple times where Donald Trump's reaction to either a criminal investigation or criminal charges results in additional charges. In the civil case with E. Jean Carroll, where she succeeded and won a defamation case, she was actually able to file an additional defamation suit after Trump's reaction to her victory for defamation. And so that's now pending in civil court. Any good defense attorney will tell you, close your mouth, stop talking, please don't go out and make public statements. It's more important that you win in court than you win in the court of public opinion. However, he's also a political candidate, and Donald Trump is actively fundraising off of these indictments and these investigations because he's like, hey, I need money, to fight this, this corruption. These people are coming after me. It's the deep state, and people are sending him millions and millions of dollars, and he has spent millions and millions of dollars on attorneys, not just for himself, but also some of his co-defendants in the federal cases, We don't know, because the indictments were just handed up, if he's going to do the same in Georgia, but it's very possible they'll have attorneys, some of these co-defendants, who are paid by Donald Trump, or at least by the Donald Trump political campaign. It's actually a separate, it's a political action committee, and the Save America Political Action Committee, and that money can be used to pay for legal fees. So I have a document in front of me. This is right here. This is part of the indictment. And remember, I mentioned there's 41 counts. Those are the actual criminal charges. But then under that, there are well over 100 individual acts. And again, those acts aren't necessarily criminal, but the argument is they were acts that were in furtherance of the criminal conspiracy. And so in Act number 84, we have on or about the 14th of December 2020, that's an important date, that's when the electors would meet across the country in 50 different state capitals, including Georgia's General Assembly. David James Schaefer, he was the GOP chair at the time, and Shaw Micah Tresher Still committed the felony offense of false statements and writings. So what this is about in Act number 84 is kind of important, because this is the so-called fake or alternate electors plot. So in Georgia, on December 14th, 2020, 16 Trump electors met in room 218 of the Georgia State Capitol. The reason they met in the state capitol is the rules are that for the electors to cast their ballots, they have to physically be in the state capitol. So they were able to go into the state capitol, not into the Senate or to the House chambers, because that's where the actual real electors were meeting. Those were the Biden electors, because once Biden wins the state, his slate of electors cast the electoral votes. But instead, these electors went into the room 218 for Trump, cast their ballots for Trump. But here's the most important thing. So why is this in an indictment? Why is this in an indictment? And when they were just provisional, these were just provisional electors. That was the argument. The argument after the fact was, hey, we were just casting these to say, if Donald Trump prevails in court, this sort of preserves Georgia's electors. Because if there were no electors, let's say the Biden electors all cast their ballots on December 14th, 2020. Then Donald Trump prevails later on in a challenge, and the election is indeed overturned. There was determinative fraud, and this is all hypothetical, of course, and we know it's not true now. But at the time, let's just say the election's overturned, it goes for Donald Trump. But the electors cast their ballots for Biden. Guess what? Georgia gets no electors. The electors for Georgia wouldn't be counted. So there's a strong argument to be made, hey, we need these provisional electors. So the Trump electors meet December 14th, they cast their ballots, and they affirm we're the Trump electors should this actually end up getting overturned. But that's not what they said. That's not what they signed. The reason this is in an indictment, and the reason it's indicated as a criminal act, not just a, Act number 84 is in violation of OCGA 161020, which is false statements and writings. What's the false statement here? The electors signed their names to a document saying they were the duly elected electors for the state of Georgia. Now in Pennsylvania and one other state, they said, no, this is just in case. These are just provisional ballots. That's not what they did in Georgia. That's not what they did in 5 states, including Georgia. They actually signed a document saying we are the duly elected electors. And that Fani, Willis, and the grand jury have concluded was a false statement and writing. That's the criminal charge, probable cause for this to go to trial. Of course, this is all just alleged, and it's going to be the subject of a criminal trial, at least a criminal prosecution at this point. And these 2 men that I just listed, Mr. Still and Mr. Schaefer, are innocent until proven guilty, and they have the presumption of innocence under our justice system. But essentially, what they're going to have to do is defend themselves against these criminal charges for simply casting electoral votes for Donald Trump when Joe Biden won the state. That's what it really comes down to. But it was more than that. They put it in writing, they signed their names to it, and they sent it off to the Senate, and they sent it off to the U.S. Archives, the National Archives. And the part of this, the argument in the indictment, both the January 6th federal indictment and the Fulton County indictment, the argument is this was in furtherance of a conspiracy of a plot to get Mike Pence, the vice president at the time, who was the presiding officer of the Senate, as the president of the Senate, because the vice president is the president of the Senate, when opening the ballots on January 6th and counting them, that there would be these competing slates from at least 6 states, including Georgia. And so when Mike Pence would open the envelopes, he'd say, wait, there's one from Georgia here for Biden, and there's another one here from Georgia for Trump. I don't know which one to accept. And what they were trying to do, according to Mike Pence himself, was to get him to say, I can't accept either of these slates of ballots, slates of electors. So I'm going to discount or not count Georgia, Pennsylvania, Michigan, Arizona, Nevada, New Mexico, and these so-called contested states. And the argument then would be that no one would get to 270 electoral votes because all of those states went for Biden. And if he doesn't get 270 electoral votes, then he doesn't win the presidency. And the Constitution says that that then goes to the House of Representatives. And the way that works, and it hasn't happened in our lifetimes, obviously, it hasn't happened in modern times, the presidency, when selected by the House of Representatives because nobody gets 270 electoral votes, the process is each state delegation in the House of Representatives gets 1 vote. So that's 50 states, 50 votes, right? And at the time, the state delegations were split 26-24. There were 26 states that were Republican delegations. There were 24 states that were Democrat delegations. And so the idea is the House of Representatives will narrowly select Donald Trump instead of Joe Biden, and he's the next president back in 2020. The problem with that, that nobody ever mentions except for me apparently, is that Liz Cheney was the sole representative from the state of Wyoming. Wyoming has 2 senators, but only 1 representative. And at the time it was Liz Cheney, and Liz Cheney was not about to vote for Donald Trump. I don't know if she would have voted for Joe Biden. I don't know what she would have done, but she has indicated she wouldn't have voted for Donald Trump at that time. And as a result, you would have had a split. You would have either had, or maybe she would abstain, and then you have 24, 20, what would that be, I guess? And instead of 25-25, you'd have 24-24, right? And then what do you do? Or maybe it would have been 24-25 and it would have passed. I don't know. I mean, it would have been really narrow, let's put it that way. But if she voted against, then it would have really thrown things for a loop. But it never came to that. This was the plan that is alleged to have been hatched by John Eastman, who was or is an attorney and a former law clerk for the U.S. Supreme Court. He was one of Clarence Thomas's law clerks, and he's considered a scholar. Some people consider him a scholar on the Constitution. And he had this argument that, hey, all we have to do is create enough doubt that, that throws it to the House of Representatives, and next thing you know, Donald Trump's president of the United States. And that's why he's also criminally charged, because this allegation is that rather than this being just sort of legal advice, that John Eastman was actually a participant in a criminal conspiracy. Again, that's just an allegation. The argument is going to be advice of counsel. There's a couple of things that are difficult when your defense is advice of counsel, because if you say, I did this on advice of counsel, there is some protection. Hey, my lawyer told me to do this and told me it was legal. Because what that does is it erases the criminal intent, right? I wasn't intending to break the law, but my lawyer told me it was legal, so in good faith, I followed my lawyer's advice. The problem with that is if the lawyer gave you advice that actually was a crime, then the lawyer could be part of the conspiracy, and also there's no attorney-client privilege at that point, because there's a crime-fraud exception in the attorney-client privilege. Attorney-client privilege basically means that if you get advice from your attorney, that's between you and your attorney. It's just like there's a privilege actually between husband and wife. There's a privilege between a married couple. There's a privilege of the confessional, things said to a religious person, like a confession. But one of them, and it's the strongest one really, is the attorney-client privilege. You have to be able to get advice from your attorney that you don't have to share with the prosecutor or anybody else. But if your attorney is involved in the crime or a fraud, that's the crime-fraud exception, and the attorney-client privilege is therefore no longer in effect. The other issue, though, is if you claim on advice of counsel, you say, I did this because my lawyer told me, well, you're waiving attorney-client privilege at least related to that advice, because if they say, hey, if you say, my lawyer told me to do this, well, then they say, well, what did your lawyer tell you? Oh, sorry, attorney-client privilege. No, you're claiming this as a sort of an affirmative defense. You know, that hey, I could not have committed this crime because my lawyer told me to do it. Well, then what did your lawyer tell you? And so that makes it very difficult because then that kind of opens up the floodgates. And they already have been. I mean, a judge has already ruled in the January 6th case and in other cases that Donald Trump is facing that the attorney-client privilege simply doesn't apply. So these are all things that we're going to have to look at as this case goes forward. The other issue we've got coming up, of course, is really just starting with RICO. Everybody's been talking about RICO. In fact, there's actually a really great tweet that's going viral right now on X or whatever they're calling it. Somebody, because people keep saying RICO law, and somebody put up the guys from Ricola, Ricola, because people keep saying RICO law. So they put up a picture of those guys blowing their pipes up there in the what is that? The Swiss Alps, I think, isn't it? Anyway, good image. But we all needed a laugh after getting no sleep last night. But what it really comes down to is we're all becoming suddenly overnight, amateur experts in RICO law, and we're talking so much we need a RICO law. But essentially, RICO law has the issue in Georgia of it being very different than, or at least broader than the federal act. And that's good news for Fani Willis. It may be bad news for Donald Trump, and we're going to have to see how that goes. I'm going to be handing it off now to Joy Nakrin, who's going to be taking over and is going to be joining me, and we're going to be talking about with an attorney about RICO law and all of that. So I'm literally going to step out of the shot, and Joy's going to step in, and Joy also has had no sleep. So she's going to appear here momentarily once we come back on camera. For now, though, I'm Brendan Keefe, Chief Investigator for Atlanta News First, and you're watching Atlanta News First Plus. Stay with us. We are continuing our coverage right now.
Thank you, Brendan. Well, I have to tell everybody I don't have a RICO law, but I have a Halls because we have been talking a lot, and I have had a bit of a cough. So I apologize for that in advance if that does happen when we're on. And you know what? I'm gonna need to adjust. Pardon me while I adjust because I'm not as tall as Brendan. I'm just kind of adjusting my camera a little bit for so that I can be at Brendan's level, at least physically. But look, we've been talking a lot about the RICO statute, and I want to just break down. So what does RICO stand for? Well, first of all, let me point out this is the top count on this indictment form, right? Is RICO. And it stands for, it says it right there, a violation of the Georgia RICO statute, right? RICO Act, Racketeer, Influence, and Corrupt Organizations Act. So that's what RICO is. And I think that Brendan got a little bit into this, but historically, the RICO Act was developed to target gangs, organized crime. But here in the state of Georgia, it's somewhat unique that Fani Willis has employed the RICO Act to prosecute non-gang activities, such as in the Atlanta teachers case. Obviously, the YSL case, which is underway right now, that is alleged to be a gang, right? But it really kind of points to one of the other unique elements of RICO, or consequences of prosecuting under the RICO Act, is, look, we're already in a historically long trial where the case in chief, hasn't even begun. The trial's not even underway. We're just in voir dire right now for YSL. It's jury selection, and we're already the 8th month into the year. It started in January. We're still going because, it becomes very complicated when you've got so many defendants and you've got so many charges. So that's certainly something that's on the radar with this particular case, because we're talking about 19 defendants, including the former president, and all of them brought in under this umbrella of RICO, all of them charged with that particular count of violating the RICO Act here in the state of Georgia. So what are the implications of that? It's estimated that the trial itself, once that begins, it's going to take at least a year. But let's not forget, there's so many steps that have to be taken before we actually even get to the trial itself. First of all, I believe Brendan laid out for you, but maybe some of you are just joining us, that the former president has until next Friday, August 25th, to turn himself in. And what happens after that? Well, then you have an arraignment. And that is when the charges are formally read to the defendant, and the defendant has a chance to actually enter a plea of guilty or not guilty, or it can be done on his behalf by his attorneys, or he can waive his arraignment and not appear. Some people do that, especially if they want to avoid publicity. And then, there are going to be so many hearings, and there's going to be pretrial motions to exclude evidence. That's typically what we see. Motions to include evidence, motions to call certain witnesses, motions to, exclude certain witnesses from each side, going back and forth. And that's kind of all the stuff that happens before an actual trial takes place. Somebody who knows very much about this and actually tries many cases in that courthouse, Fulton County, is attorney Holly Waltman, who is joining us here today. Holly, thank you so much for being with us. And Holly, I know you've been following this case so closely as well, so really appreciate you joining us. We're talking about RICO. We started, there's so much to talk about. We're talking, we've got 41 counts and 19 defendants, so there's a lot to talk about. But when we're talking about RICO specifically, why is it so appealing to prosecute under RICO?
Well, I don't know that I'm ready to say it's appealing. It definitely
For a prosecutor.
For a prosecutor, it can be appealing, but it also comes with more challenges, right? With more details, with more expansion of their jurisdiction and ability to prosecute felonies within Fulton County comes more challenges from defense and legal teams. So it can be more advantageous for a prosecutor to try and add a RICO charge to an indictment in order to bring multiple defendants together, spanning over multiple alleged acts or multiple alleged schemes that could have occurred in violation of Georgia law. But also with it, Joy, I want to remind everybody that it is also dangerous to indict under a RICO statute, because it also allows the defense teams, and in this case, 19 different defense teams, to challenge certain aspects like jurisdiction and causality and the connectedness of these people that are now finding themselves in an indictment together.
Yeah, no, that's an excellent point. It's an excellent point. I also want to ask you, you were talking about just kind of how expansive this indictment is and the fact that there are 19 people. Something that, people have kind of been trying to figure out is, we look at this list of 19 defendants, very high-profile defendants, not only the former president, but, his former attorneys, Rudy Giuliani, John Eastman, Sidney Powell, former chief of staff Mark Meadows, and the list goes on. But who is potentially more culpable? Who should be more concerned about successful prosecution against them? Who do you think is most likely to be convicted?
Well, I think there's two ways to tackle that question, Joy. The first one is to remember that this is an indictment. These are just allegations that the state believes they have evidence to prove beyond a reasonable doubt. These, in fact, are not evidence of crimes themselves. They rather are just kind of the outline or the framework in which the state will put forth evidence. So the indictment itself is not evidence whatsoever. That's the first thing to remember. But second, it is sort of a hint, right? It is sort of a roadmap. And I think, just like our Constitution of this great country, is in order of importance. I think right at the top, the very first defendant that we see, the former president, is likely, with his most coveted and legal counsel, Rudy Giuliani, right behind him, probably at the top of the most wanted list for Fani Willis and this district attorney's office. I think the people that find themselves closer to the bottom of this 19-person or defendant list that have, beside their names, a few less charges or a few less counts that they're associated with, I think that those people are the ones that, while they still should be very concerned because they are now accused formally with a charging document of serious felonies, are probably just a little bit less culpable or a little bit less vulnerable to what this district attorney's office is trying to accomplish here.
And since that's kind of the roadmap for you, I just want to point out that the people listed on the top, because you do think that that correlates to kind of the order of culpability, top of the list, excuse me, is Donald J. Trump, followed by Rudy Giuliani, followed by John Eastman, followed by Mark Meadows, and so forth. So perhaps that's an indicator. What else would you say about those particular defendants?
Well, you know, one thing that I think was notable yesterday that we saw that still has quite a bit of, you know, I guess, question around it is how Donald J. Trump's charges that we find almost exactly mirrored the charges in this indictment were leaked onto the clerk's website. And I think that the grand jury, once they concluded hearing testimonial evidence from the individuals that were summoned and subpoenaed to present evidence, I think that they took the list straight down the top. And I think the first individual, or the first defendant, now defendant, that they voted on was defendant number 1, Donald J. Trump. I think those results got handed to the clerk and then somehow accidentally got published for everyone to see, and then, of course, quickly removed.
Very interesting. Yeah, because I've had some viewers reach out on social media and say, you know, how was that report released while the grand jury was still voting? And so that's you know, a reasonable explanation that the grand jury was basically going down the line of defendants and voting, you know, as to each one, whether there was a true bill or a no bill, and had, you know, if Donald J. Trump was on the top of the list, had already voted on that because, right, what we saw leaked erroneously yesterday does actually correlate to what we see in the final document.
Right. And Joy, we don't know that for a fact, right? We've had no one come out from the clerk's office, no one come out from the district attorney's office and say that's exactly what happened. But in my experience as being a trial attorney, both as a prosecutor and defense attorney, I find that juries, and in this case a grand jury, typically take things logically. They take things, count 1, we find them guilty or not guilty. Count 2, find them guilty or not guilty, so forth and so on. I think it just kind of makes sense. But again, of course, it's not something that we know for a fact. And honestly, I don't think we will find out any more information about it. And in the grand scheme of this huge, massive undertaking by the district attorney's office, in this case, I don't think that it will actually make any bit of a difference.
Yeah, interesting. So let's talk about, you know, we've talked a lot about RICO, but let's talk about some of these other charges. You know, I see numerous conspiracy counts here, and solicitation of violation of oath by public officer, numerous of false statements. What do you think is really most significant, and is there anything missing from this list that you think maybe should have been there?
Well, it's really hard to say because, like I just mentioned, this indictment is not, in fact, evidence of anything at all, other than what the district attorney of Fulton County believes they can prove. And so these charges sound super interesting, super involved, and part of something much larger or greater than any one individual in this indictment, which is pretty much the premise for the RICO Act in this case, which is count 1 of this indictment. It will be very interesting to see the evidence that we will maybe be privy to pre-trial, but definitely here during a trial, should any of these 19 individuals stay for the long haul and decide to exercise their right to have a trial and have Fani Willis's office prove them guilty beyond a reasonable doubt. She will have to back that up with phone calls, phone records, emails, correspondences, something with a little bit more meat than what we've already just heard, which is basically the phone call between former President Donald Trump and Brad Raffensperger.
Right. And, you know, we would anticipate that there would be text messages and other written communications as part of evidence. And that seems to be indicated in the indictment as well. You know, one potential piece of evidence might be that heavily edited video that, you know, Rudy Giuliani presented to the Senate Judiciary Subcommittee here in the state of Georgia, in the Georgia State Senate. And it's something that is talked about in this indictment, also the federal indictment, as basically being a false representation. The charge actually for that, I believe, is false statements in writings, count 3, implicating Rudy Giuliani. And, you know, this was all in sort of this storyline of voter fraud, these claims of voter fraud. And that's when we saw the two ladies, a mother-daughter team of Ruby Freeman and Shay Moss, who were accused of basically of this kind of voting, voter worker misconduct and facilitating this voter fraud and, stuffing these suitcases with fake ballots and of dead people allegedly and all that. But I'm wondering, if that piece of video, what else do they need to really build that case around that chain of events?
Well, Joy, I think notably and hinted inside the indictment are these individuals that are known to the grand jury but unknown to us at this time. And the DA is doing that in an attempt to keep their identity private, to keep them safe from any kind of outside influence, which is really the nuts and bolts of what this indictment and this criminal enterprise is alleged to have done, right? To interfere with official business, government business, and elections. So while we can see a video, while we can hear a phone call, while we can review text messages, and those can all be credible evidence, I think that there will be a large portion of this trial that will come from these now unknown to us but known to the grand jury witnesses that will have firsthand knowledge of phone conversations or verbal conversations that happen between these individuals that are now charged.
Yeah, very interesting. So, let's talk a little bit about the timeline, because everybody wants to know what's next. We've talked a bit about, what arraignment would look like, the fact that he has to turn himself in by next Friday, August 25th, he being the former president, and so forth. But, Fani Willis expressed that, she was hoping to get this thing to trial in 6 months. We all know that before trial, there are numerous pretrial motions that are filed by either side, usually related to evidence that can be presented, witnesses that can be called. One side wants to bring in witnesses and evidence, and the other side wants to keep it out, that sort of thing. Do you think 6 months is realistic?
I will be absolutely shocked if Fani Willis or any prosecutor, and this is not a slam to her, I would be shocked if any prosecutor could bring a 19 co-defendant indictment of this magnitude with these type of defendants that are going to have sometimes ample resources, sometimes unlimited resources for legal teams that they're going to put together. After an arraignment, of course, we know that there will have to be discovery served on all 19 of these defendants' legal teams. They will have to be given a significant amount of time to review that with each one of their clients. There will be pretrial motions based off of that evidence, and sometimes prosecutors, on accident or maybe on purpose, leave out first rounds of evidence that is given out to defendants, and there has to be requests from third parties to get certain records that the defense teams believe that they need in order to adequately and effectively represent their clients. Of course, after those motions, there will be a calendar call, or what's called status calendar, to see exactly, Judge McBurney's going to want to know where are we all at. And then from there you start the process, the very difficult process of trying to line up 19 defense team attorneys' schedules with the prosecutor's schedule, which also has to align with the judge's schedule. I think that would be an extremely hard timeline to meet, and perhaps last night when she spoke, she hopes to, at least within 6 months, have an idea of when trial would start, but I don't believe that is going to be a realistic endeavor.
And then in terms of how it's actually going to work as well, because we are talking about 19 defendants, because with the RICO count, excuse me, surely we would see the 19 tried together. But is there a case to sever, I guess, trial on related to other counts? Is there a case to be made for that if you're the defense attorneys?
Certainly, absolutely, and I think that we will see multiple challenges for multiple different reasons, both constitutional and otherwise, evidentiary. When you have this many people lumped into an indictment of this magnitude, there's all sorts of arguments that could be made for on behalf of individuals that are not charged with things as serious as other individuals. Some of their defenses are going to be conflicting, meaning that defendant number 17 is going to point the finger and said, well, I didn't really do this. Defendant number 18 made me do this, and I didn't know really that this was false information that I was spreading. Those sort of things are going to create and cast a web that is going to be very complex, very challenging. It is going to be, in my opinion, more difficult to tackle this trial than the YSL trial that she is currently in the middle of trying to prosecute.
So, what about potential defenses here? I've heard the argument that the former president could say, look, I didn't have the appropriate mens rea. essentially the mental state. My intention wasn't to actually get Brad Raffensperger to get me 11,780 votes. I was just telling him that's what I need. Like I could tell you, Holly, I need $1 million. I'm not saying you need to get me $1 million, but it would be nice.
Yeah, certainly. I mean, look, what we do know about the former president is that he is not going to just roll over and take sort of responsibility for anything like this. What I do know about his legal team, or whatever legal team he is currently getting together, is that they hope and pray that he will keep his mouth shut and not say what it is he knew or didn't know, or what his mens rea might have been or might not have been. If he can do that, then yes, his legal team will have several challenges that they'll be able to bring. Now, will they be successful in bringing them? That is yet to be determined. Judge McBurney is an excellent judge. He's very well versed in the law and understands RICO statutes extremely well. I trust that he will listen to both sides and make the appropriate call. But yes, we will see challenge after challenge. And Joy, it's also noteworthy to mention that a motion to sever, to get away from the group, rather, to get a trial on your own, is going to be renewed throughout the process. So the first time that a defense team says, hey, I need a new trial separate from everybody else because my client is seated differently or is in a different position, and if that request is denied by the judge, it is a request that can be renewed at the beginning of a trial, during the middle of a trial, again and again for other various reasons. So it is something that is not just a one and done, ask, denied, and then you have to keep going. It will be something we will see asked and requested several times over, because of course if we get one of these individuals a separate trial for one of these 19 defendants, then of course the possibilities of their defenses open up way wider, because then they can say, hey, it wasn't me, it was everybody else that's left in the big pack that's separate from me.
Well, because of how, just to put it bluntly, messy this thing could get, do you think we're going to see plea deals for many of these defendants?
I think that we could definitely see plea deals. There will be plea offers extended to at least some of these defendants. Now, whether or not they're interested in taking those plea offers, if it's something that they can wrap their head around, or if risking going to trial is something that they are adamant at doing, which I think some certain defendants will absolutely demand a full dismissal or a trial in this case. I think that we will see a certain number of defendants in this case take responsibility for their portion. And part of that plea negotiation, part of that deal or that plea agreement that Judge McBurney would then ultimately be in charge of accepting or not accepting, would also include them testifying on behalf of the state to order and help try and prove the rest of the counts for the rest of the remaining defendants. There's an adage, Joy, if you get offered a deal and you're even considering taking it, you have to take it first, you have to take it quick, because once they have someone else in place that's accepted it, your deal is going to be taken off the table and you're going to be left with the rest of them.
Oh, wow. Yeah, that's a great point. That's a great point. Thank you so much, Holly Waltman, for joining us with your insight and analysis. I just really want to point our viewers to our website, because honestly, our web team has done an amazing job. I'm not just saying that because I work here. I mean, this is really kind of a go-to resource even for us internally at the station to sort out this extremely complicated case, because again, this is the fourth indictment against the former president. Let's not forget the state charges out of New York for the alleged hush money payments to Stormy Daniels via former attorney Michael Cohen, and the federal counts out of the Florida federal court related to alleged mishandling of classified documents. And then most recently, before Georgia, we had the Florida federal case, the DC federal case, also related to the alleged election interference in 2020. And then we have this. So that's why this timeline section is really, really helpful, what I'm going over with my cursor right now, just to help you sort it out. And then the key figures on AtlantaNewsFirst.com, our whole section, you just click on here, Trump investigation, and it lays out everything for you. We have so many articles about this, and this is very popular right now. Look, the call that started it all, you can actually listen to that whole phone conversation, make up your own, draw your own conclusions after you listen. But thank you so much for joining us on Atlanta News First Plus, and we're going to continue our coverage also on our mobile news app and AtlantaNewsFirst.com. We really appreciate it. Have a great day.